Good day, IAM siblings. I'm here to share with you two significant developments in labor law that will enhance our organizing efforts. First, there are new amendments to the National Labor Relations Board rules, also referred to the NLRB rules, that are intended to remove barriers and delays with union elections and promote speedier, fair, and more efficient elections. Second, there is a recent landmark decision that is intended to make it easier for workers to form a union and hold employers accountable for illegal conduct that impacts the outcome of elections. Okay, let's talk about the return to speedier election rules. There are two major changes to the NLRB rules that allow for faster processing of our union elections and faster administration of elections. Under these new rules, union elections can be administered in as few as 15 calendar days from the date of filing for an election, which is more than twice as fast as the minimum 34 days under the Trump-era rule. That rule ultimately averaged anywhere between 15 and 70 days between filing the application and for an election and the election itself. These reinstated speedier rules were originally implemented during the Obama administration in 2014 and were replaced and revised during the Trump administration in 2019. The Trump-era rules essentially slowed down the election process and allowed more time for employers to implement union-busting tactics before and during a union election. The NLRB overturned those rules, and the reinstated rules become effective December 26, 2023. Our second pivotal development is a brand new decision that will improve workers' rights to form a union and hold employers accountable when they engage in illegal conduct. The decision is Cemex Construction Materials Pacific, LLC. Through this decision, the NLRB's General Counsel, Jennifer Abruzzo, argued for the restoration of a case that was overturned 70 years ago, known as the Joy-Silk Doctrine. This doctrine supports the requirement that an employer recognize and bargain with a union when there is proof that a majority of workers support authorizing the union to be their bargaining representative. For example, under this new decision, where there is at least 50% plus one of workers that sign authorization cards and the employer refuses to recognize the union, the employer may be found to be in violation of the National Labor Relations Act. If the employer has legitimate doubts of the union's majority status, the employer has the option of promptly filing a petition for an election. If the employer does not file for an election and refuses to recognize the union's majority support, the board may issue an order for the employer to bargain with the union without having an election take place. And in cases where an election does take place and the employer engages in illegal conduct that is likely to affect the outcome of the election, such as intimidation, coercion, or interference, rather than ordering a rerun election like the board did in the past, now the board can order the employer to recognize and bargain with the union regardless of the election results. This new remedy acts as a significant deterrent to employer unfair labor practices during organizing drives. Essentially, once we prove that the employer has committed ULPs and they have affected the outcome of an election, the employer may be ordered to recognize and bargain with the union. In light of this new decision, we recommend some changes in our organizing campaign procedures. First, before filing a representation petition, we should communicate with the employer in writing. In this letter, we should assert that we have the support of the majority of employees in a defined bargaining unit, demand that the employer recognize the union by a specific deadline, and notify the employer of our intention to seek an order to bargain if recognition is not granted. Secondly, if an election takes place and the employer commits ULPs that could affect union support before or after the election, we should take action. We should file ULPs for all illegal conduct, and if we lose the election, file an objection within 7 days asserting that the employer's ULPs affected the result of the election. And if ULPs continue to occur more than 7 days after the election, such as termination or discipline of union supporters, we should file ULPs for those as well. These changes in NLRB rules and procedures represent a significant step forward for speedier union recognition and ensuring a fair process during organizing drives. However, we must be proactive in our approach, and these recommendations will help us navigate these new developments effectively. Now let's take advantage of this moment and continue to promote workers' rights and grow our union together.